Approximately a year ago, the Constitutional Court decriminalized the private use and cultivation of cannabis by adults. Accordingly, the private use and cultivation...
Please ignore me.
The private use and cultivation of cannabis is no longer illegal, provided that it's not consumed in public, distributed, sold, or used by minors. Accordingly, the private use and cultivation of dacha, as homegrown locals would say, is no longer chacha. That said, the sale and distribution of the plant and certain specified products is still illegal in South Africa. In this regard, it is very important to recognize the two main components of which the plant consists. The plant consists of cannabidiol, more commonly known as CBD, which has no mind-altering effects, the good stuff, or tetrahydrocannabinol, or THC, which is the psychoactive component and is actually the component that gets one high. Thank you. Okay, the importance of this distinction is crucial in understanding what can be commercialized. In May of this year, the then Minister of Health, Dr. Motsoaledi, in a government notice exempted the sale of certain health products for a period of 12 months. So what this notice did is, it removed CBD, not intended for therapeutic purposes, from a Schedule 7 drug and placed it into a Schedule 4 prescription drug. What this means is that certain approved products containing a specified amount of CBD can now be purchased over the counter from your local pharmacist upon presentation of a written prescription. And secondly, and most importantly, certain products containing a minuscule amount of CBD and even less THC are now available for sale by the public. And unfortunately, this exemption will expire on May 2020 unless renewed. This has created a window of opportunity for the development and sale of a multitude of new CBD-containing products. As you can imagine, many Mary Jane merchants have already jumped at this opportunity. South African market for marijuana and associated products could potentially be worth 27 billion per year by 2023, so rightly so. This is in accordance with what the Prohibition Partners said. This is a London-based firm which specializes in independent data and intelligence and strategy for the international cannabis market. And as you can see on the products on the screen before you, these were taken and showcased at the Cannabis Convention in Cape Town in April this year. Many people have already done so. As you can see, there is a hemp-containing beer already on the market, cannabis dog treats, CBD-infused gins and vodkas, gummy sweets. A company called Canna Coffee even had cannachinos available at the event. So as you can see, the application of CBD in relation to products is potentially limitless. Nevertheless, prior to launch into market, a number of intellectual property considerations should come into play. Depending on the product, 6 different types of IP can be applicable. These are copyright, know-how, trademarks, patents, designs, and plant breeders' rights. I will be taking you through copyright, know-how, and trademarks, and our patent specialist, Peter, will be taking us all through patents, designs, and plant breeders' rights. Okay, starting with the first 2, copyright and know-how. These generally do not need to be registered. They exist automatically and are basically free of charge, except maybe for cinematograph films. Copyright does not subsist in ideas. Copyright subsists in any original work, such as a literary, musical, or artistic work, which has been reduced to material form. For example, if we're looking at the slide here, copyright will subsist in the drawing on the background of this CBD-infused gin, or in the design of the logo. Know-how, on the other hand, relates to the confidential information or trade secrets that you may, for example, have in your recipe or formula in your hemp-containing beer. You can't register these rights, but you can ensure that the necessary confidentiality agreements and non-disclosure agreements are in place with relevant third parties or employees. Moving on to trademarks. I'm sure you all know what a trademark is and that there's a difference between a trademark and a patent. A trademark is your distinctive brand name. It's your logos, your marks, your so-called badges of origin used to distinguish one person's goods from another. You do not need to be using a trademark to register it. Use, an intention to use, or to license to another person for use in future is enough. This is beneficial, especially in light of the cannabis legislation that is still in flux, and in light of the May 2020 exemption deadline. Because a trademark generally takes 2 to 3 years to register, but you've got rights from the day you file the application. That being said, certain trademarks cannot be registered. The Trademark Act precludes the registration of trademarks which are contrary to law or likely to give offence to any class of persons. As you saw on the slides before, if we look at these products, they all have a little cannabis leaf on them, or they refer to cannabis or CBD or hemp. Marks consisting exclusively of such matter can't be registered on their own, and you're going to have to be really creative in order to overcome them. If we look at this mark here, and if you look at that cannabis leaf, it's not actually a cannabis leaf. It's 5 surfboards on top of each other. So that's how that guy got his trademark. And then, especially, marks that are contrary to law, or as with regard to your exemptions, this might be a problem if you apply to register a trademark in relation to goods that you can't sell. And then, as more and more products are coming to the fore and more people are bringing their products to the marketplace in South Africa, I think it is highly unlikely that you might be unable to register a trademark which would give offence to any class of persons. Then I've taken the liberty of drawing 2 register pages just to show you what I mean in this respect. If we look at the register page on the left there, some person has already applied for the trademark weed in relation to smokers' articles. As you can see, it's been provisionally refused for obvious reasons. And then on the other side here, we've got Durban Poison Cannabis Lager, which has been accepted with conditions. Why? Because it doesn't consist exclusively of, for instance, the words cannabis or lager. We can definitely help you if you're interested in filing a trademark application for your dope brand. And I just want to, as a final remark, say that if you are cultivating for private use a new strain of cannabis in your backyard, just remember you can apply to register a name for it, but you'll have to endorse that mark saying that it won't be used as a varietal name, but you may be able to obtain plant breeders' rights in it, and Peter will be able to tell us how you go about doing that. Peter?
Thanks, Danielle. We're all sufficiently tripped and high now. I think if you'll probably glean from Danielle's presentation as well that the Constitutional Court judgment has not really changed anything significantly in relation to intellectual property laws. The only aspect that I think one can probably arguably say it has placed registration squarely outside of is that prohibition that Danielle also referred to, and that's applicable to patent law as well, that you cannot register anything that's contrary to law, gives offence or something like that. So where you could previously quite have argued about that, I think now we know that squarely it's cannabis-related products are all placed outside of that prohibition. Therefore, from a patent perspective, we're very much dealing with Patents 101. I'll quickly run through the distinction between designs and patents, as most of you would probably know. That registered designs protect the appearance of an article of manufacture, whereas patents protect functional subject matter or inventions of functional subject matter. And neither of these, as I've mentioned, has got any special considerations relevant to cannabis that arise from the Constitutional Court judgment, except, of course, that exclusion that I referred to. But that's a whole argument on its own. I don't believe that we have time to explore that in significant detail. Our patents and designs, as you will see that they have got a common validity requirement in the sense of novelty, requiring, broadly speaking, and we can go into the detail that I won't do now, that both the inventor of a product, of an invention, must not yet have disclosed that product to the public, and the product must also not yet have been disclosed, or the invention must also not yet have been disclosed to the public by any other person anywhere in the world. That's a registrability requirement. Now, in the sense of cannabis, the prior legal status of cannabis has prevented publications proliferating in the industry. And therefore, if you're looking at pursuing patent protection for a cannabis-related product, you are in many instances quite likely to get patent protection for it, and in fact to get quite a broad scope of patent protection for it. From a freedom to operate perspective, that is quite concerning in the sense that quite a few products that might be patentable might well fall within the scope of currently existing patents, because the scope of protection that was granted is so broad, seeing as the prior art that would be relevant to the assessment of the patentability of those inventions is so limited. So if you are looking at entering into the market in relation to any specific cannabis-related product, it might be worth checking which kinds of rights from a patent perspective have been registered. And I'm focusing particularly on patents because design rights, as you will gauge, is probably only relevant to containers or smoking articles or things like that. But to see to what extent there might be limitations on your ability to exploit the technology, even though you might be able to patent that technology. If we look at the utilization of the patent system in relation to cannabis-related products, you can see that there's been a significant spike in the application profile. These focus or look at the USA and EPO number of applications that have reference to either cannabis or one of the components of cannabis that Danielle has referred to in the claims. So since the last 10 or so years that there's been a move towards cannabis becoming legal in many respects. In some countries there's been a significant uptick in the research that's conducted in relation to this type of product. The inventions that are being patented, I won't linger on. You can look at these slides when they're available after the Crammer. Just some examples of technologies that have been patented in the field. There are some simpler technologies that I've found subsequently, and this actually speaks to the scope of protection that I referred to earlier, in the sense that one of the products is simply for a coffee, one of these coffee capsules. What's the brand name? They're pods, yeah, one of those coffee pods that simply has cannabis in it in a certain way that it was configured, and that it's present in the form in which it's present in that product. But nevertheless, it's a very broad scope of protection that would actually obviate many people from exploiting that particular technology, even though they might come up with patentable technologies. All of that said, there's a list of some relevant subject matter that you can pursue patent protection for. Again, I'm not going to expand on these in too much detail, but for your information, that if you're working with subject matter in that kind of field, that's probably what you would look at for pursuing patent protection. If we're considering the activity that I showed earlier, there is quite obviously, I believe, a lot of activity from the pharmaceutical industry. These are the leading applicants of patent applications for cannabis-related inventions, particularly in the US and Europe, which as I say, unsurprisingly, include most of the pharmaceutical companies. Briefly dealing with plant breeders' rights, I was actually surprised to learn that various varieties of cannabis exist. I thought there was only one. The names are very offensive, as you can see. It would be surprising to pull some of those things into your lungs, from my perspective at least. Now, there's plant breeders' rights. They generally grant exclusivity, or broadly speaking, grants exclusivity over the propagating material that of a particular variety, and the registration requirements of a variety to be registrable are identified there. If I can make a final brief comment, the distinction between patents and plant breeders' rights is essentially that plant breeders' rights are more relevant to the so-called biological breeding of plants, whereas patents are more relevant to the microbiological processes and products of such processes, which leads on to a question or leads on to a requirement for a specific scientifically technical step to be involved in the production of such products. And that is our topic. Thank you very much.